Way the form reading the indictment, his name's correctly set forth in the indictment, knows the range of punishment, what he's charged with, going to change his plea from not guilty to guilty, Your Honor.
All right, Mr. Romero, raise your right hand. I have to swear you in. Just raise your right hand. Do you solemnly swear the testimony you will give before the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Sí.
All right, Mr. Romero, if you've gone over the indictment in this case with your attorney, Mr. Clifton Roberson, so you understand all the allegations and the charge in the indictment for aggravated assault with a deadly weapon of second-degree felony.
Sí. Sí.
All right, now do you understand that indictment, aggravated assault with a deadly weapon, that charges a second-degree felony, which carries a sentencing range of not less than 2 years, no more than 20 years in the Texas Department of Corrections Institutional Division, and a fine may be assessed of up to $10,000. Do you understand that?
Uh-huh.
All right, now, Mr. Romero, we're going to go through what we call plea documents here. You're going to see them go up on the screen so I can be sure you understand all these plea documents you and Mr. Roberson have signed. They're all signed by Mr. Chamness, state's prosecutor. First one going up is the agreed punishment recommendation. It tells the court you and Mr. Roberson have agreed with the state prosecutor that if you do plead guilty to this indictment charging aggravated assault with a deadly weapon, a second-degree felony, which carries a sentencing range of not less than 2 no more than 20 years in the Texas Department of Corrections Institutional Division, that the state's prosecutor is recommending in the plea agreement that if you plead guilty, the state will recommend your sentence at 7 years in the Texas Department of Corrections Institutional Division, which will be assessed with credit for time served from March the 10th, 2020 to the present. Is that your plea agreement, Mr. Romero?
Mm-hmm. Sí.
Is that it, Mr. Roberson?
That's correct, Your Honor.
Okay. Clifton, you may need to punch your volume up a little bit.
Okay. Can you hear me, Your Honor?
Yes, I can hear you real good now.
Okay, that's correct.
Is that the agreement, Mr. Gilmore?
Yes, Your Honor, it is.
All right, the court's going to follow the plea agreement. It has checked a special condition of the recommended sentence being payment of restitution in the amount to be determined by the pre-sentence. Do we need a pre-sentence? Is there any restitution?
Yes, Your Honor. The state would request a pre-sentence in this
All right,
case.
court will order more.
Or post-sentence, Your Honor. My apologies.
I'm sorry?
Post-sentence, Your Honor.
Yes, post-sentence. Court will order a post-sentence investigation to determine the amount of restitution, if any. All right, looking at that plea document that's up there on the screen, Mr. Romero, if you look at it down the right side, on the line above where it says defendant, there's a signature. Is that your signature down at the bottom right?
Sí.
All right, it's also signed by Mr. Chamness and also signed by Mr. Roberson, your attorney, right below you. Those same signatures appear on all the plea documents. So you've already told me you understand your plea agreement. The next plea document is an acknowledgement of admonishments. It gives you the full range of sentencing. I've already been over with you. There's 5 admonishments. Your signature is right below the 5th one, along with your attorney's. Do you understand all 5 admonishments, which are explanations to you?
Sí.
Next document is a waiver of trial by jury. Waiver means to give up. This waiver of trial by jury tells the court, you tell the court that you understand you have a right to a trial by jury, whether you plead guilty or not guilty, and that understanding your right to a trial by jury, you knowingly waive, which means giving up your right to a jury trial, and you're asking the court to hear the case today on your plea of guilty without a jury. Is that correct?
Sí.
Next document is a waiver of confrontation and agreement to stipulate. Now, you have signed this document, it's your signature, and do you also swear that the information contained in this document is true and correct to the best of your information and beliefs to help you God?
Sí.
All right, the next document coming up then on your screen is going to be your stipulation of evidence. Your stipulation of evidence signed, and now I'm going to swear you to it. Do you solemnly swear all of the content, what the stipulation of evidence says right above your signature is true and correct to the best of your information and beliefs to help you God?
Sí.
Do you understand, Mr. Romero, okay, good. Stipulation of evidence now signed and sworn to by you. Do you understand that is a judicial confession and admission under oath by you to all the allegations and the charge in the indictment? Do you understand that?
Sí.
Do you understand that includes in the second paragraph of the stipulation of evidence, which is up on the screen, you stipulate, you tell me it's true that you used or exhibit a deadly weapon, to wit, a machete, that in the manner and means of its use and intended use was capable of causing death and serious bodily injury during the commission of or immediate flight from the offense. Is that true?
Sí.
All right. Court then does receive, accept, and approve the stipulation of evidence, states exhibit number 2. The next document going up is an agreement to stipulate testimony on the plea. These are all signed and sworn to by you and signed by your attorney, Mr. Romero. The next document is a waiver of appeal. It waives and gives up your right to appeal. Do you understand that?
Sí.
The next document is it's a request of a waiver of the pre-sentence, which the court approves. The other documents that the court has that'll be going up on the screen, which you can look at. There's a trial court certification of your rights to appeal. That's been signed by you and Mr. Roberson. It'll be filled in by the court. I'm going to follow the plea agreement and assess your sentence as recommended by the state and agreed to by you and Mr. Roberson. So this certification is going to say that this is a plea bargain case and you have no right of appeal and you are waiving giving up your right to appeal. Is that correct?
Sí.
The next document, again, is an advice on the defendant's rights to appeal. That's just certification on advice you've received from Mr. Roberson on your rights to appeal. Now, do you understand all these plea documents and your plea agreement, Mr. Romero?
Sí.
Do you still wish to go forward on your plea of guilty to this indictment without a jury?
Sí.
All right, I'm going to go through and ask you some questions now. The first one is obvious. First question is, do you read, write, and understand English? And obviously you don't, because we have an interpreter.
No.
Right, no, that's right, you don't. We have an interpreter interpreting for you. The next question is, have you consumed any alcoholic beverage in the last 24 hours in the jail?
No.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, nunca hago eso.
Okay, well, that's good. Have you ever been confined in a mental institution or under psychiatric treatment?
No.
Have you ever? Okay. Do you understand everything you're doing in court today?
Sí, señor.
Have you gone over everything you're doing in court today and everything about the facts of your case with your attorney, Mr. Clifton Roberson?
Sí.
Is he competent, Mr. Roberson?
Yes, Your Honor.
Mr. Roberson, is he competent?
Yes, Your Honor.
Any evidence of incompetence, Mr. Trevino?
No, Your Honor, no evidence.
All right, court notes, Mr. Gilmore, is there any evidence of incompetence?
No, Your Honor, there's no evidence.
All right, court notes State's counsel signed his and consent approved of the waiver of trial by jury. Court approves the waiver of trial by jury and all the other waivers in the case signed by the defendant, signed by his attorney. All right, now, Mr. Romero, you've gone over all the allegations and the charge in the indictment with Mr. Roberson with an interpreter, so you understand the allegations and the charge. Is that correct?
Sí, señor.
And you understand the full range of sentencing and your plea agreement with the state. Is that correct?
Sí, señor.
Do you have any questions for me?
No, es todo. Gracias.
All right, in cause number 2410696-20, what is your plea today, Mr. Romero, to the indictment charging you with aggravated assault with a deadly weapon, a second-degree felony as alleged in the indictment?
Es para mí. ¿Será culpable? No, eso es lo que firmé todo.
All right, are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Claro. Sí.
All right, has anyone threatened you in some way or promised you anything or made you plead guilty?
No, señor.
Are you entering your plea of guilty to this indictment charge today freely, intelligently, knowingly, and voluntarily because you committed this offense of aggravated assault with a deadly weapon as charged in the indictment?
Sí, señor.
Are you entering your plea of guilty to this indictment today because you have any type delusion in your mind?
No, señor.
Are you entering your plea of guilty to this indictment today because you have any type unrealistic, no reason to believe, any unrealistic hope of pardon, parole, or leniency?
No entiendo esa palabra.
Okay, let me explain that to you. The question is, are you entering your plea of guilty today because you have any type of delusion in your mind? If you had a delusion is a belief by you that doesn't exist. So if I looked out here in the back of my courtroom,
No.
if I said, why is the President Donald Trump sitting in my courtroom? That'd be a delusion. You understand what I'm saying? So do you have any type
Sí, señor.
Do you have any type delusion in your mind or any type unrealistic hope of pardon, parole, or leniency?
No, señor.
Okay. All right. Court does receive and accept your plea of guilty to the indictment. What do you have, Mr. Gilmore?
The state, Your Honor, the state will offer State's Exhibit 1, the signed plea paper.
Mr. Gilmore, can't hear you.
Can you hear me now, Your Honor?
Yes, I can.
The state will offer State's Exhibit 1, the signed plea paper, States 2, the signed stipulation of evidence, and States 3, the signed discovery compliance forms.
No objection, Your Honor.
We had no objection. States 1, all the plea documents signed or signed and sworn to by the defendant, signed by his attorney. States 2, the signed and sworn to stipulation of evidence, signed and sworn to by the defendant, signed by his attorney. The written judicial confession under oath by the defendant to the allegations and the charge in the indictment. States 3, discovery compliance admitted in. The court does find that the defendant's waiver of his rights and execution of all of the other documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find that the defendant's plea of guilty entered to the indictment in this case was entered by the defendant to the indictment in this case freely, intelligently, knowingly, and voluntarily. Court does receive and accept the defendant's plea of guilty. Moving to sentencing.
Your Honor, at this time, the state will offer State's Exhibit 4, a digital copy of the discovery.
No objection, Your Honor.
States for all the digital discovery offense reports, all admitted into evidence with no objection. Anything else, Mr. Roberson?
No, Your Honor.
All right, the court then, in this case, having received and accepted the defendant's plea of guilty to the offense alleged in the indictment, finding the evidence in the record fully sufficient to support the defendant's plea of guilty to the offense in the indictment, the court does find the defendant guilty of the offense of aggravated assault with a deadly weapon as alleged in the indictment, a second-degree felony, and the court, following the plea agreement and the recommendation of the state, the court assesses the sentence at 7 years in the Texas Department of Corrections Institutional Division. That 7-year sentence is assessed with credit for time served. Further, the court does make, based on the stipulation of evidence signed and sworn to by the defendant, the court does make an affirmative finding that the defendant did use or exhibit a deadly weapon, to wit, a machete, in the commission of the offense. That affirmative finding will be reflected on the judgment of the court. Any legal reason to bar formal sentencing, Mr. Roberson?
No, Your Honor.
Did you put states 4 in, Mr. Gilmore?
Yes, Your Honor, the state did.
The court in this case then, having received and accepted the defendant's plea of guilty to the indictment charging him with aggravated assault with a deadly weapon, a second-degree felony as alleged in the indictment, the court finds the defendant guilty based upon his plea of guilty, follows the plea agreement, the recommendation of the state, and assesses the sentence at 7 years in the Texas Department of Corrections Institutional Division. No fines assessed, court costs are ordered paid. Restitution is not indicated as due. Credit for time served is granted. The court does make an affirmative finding to be reflected in the judgment of the court based on the stipulation of evidence that the defendant did use or exhibit a deadly weapon, to wit, a machete, that in the manner and means of its use and intended use was capable of causing death and serious bodily injury during the commission of or immediate flight from said offense. Sentence is formally pronounced. Mr. Romero, I have a waiver of appeal. You've signed a document that waives and gives up your right to appeal. Do you understand that?
Sí, señor.
It's also signed by Mr. Roberson, your attorney. Are you waiving giving up your right to appeal freely, intelligently, knowingly, and voluntarily?
Sí, señor.
All right, the court does receive and accept the waiver of appeal. Mr. Roberson has written on the document in front of me, time credit 3/10/20 to the present. That's apparently, that would normally be the time the defendant's been incarcerated in Smith County Jail. The 7-year sentence is assessed with credit for time served. The court is making an affirmative finding to be reflected in the judgment of the court. Waiver of appeal is accepted. Mr. Romero, Mr. Clifton Roberson has represented you, been your lawyer in this case, your court-appointed attorney. Are you satisfied with the legal representation by Mr. Roberson? Are you
Sí,
satisfied?
señor.
You're sir? You're pleased with Mr. Roberson as your attorney, is that correct?
Sí, señor.
Is there anything else, Mr. Gilmore?
No, Your Honor, not on this case.
Anything else, Mr. Roberson?
No, Your Honor.
We will be in recess on this case. The defendant, Mr. Romero, is continued in the custody of the sheriff until such time as he can be transported to the Texas Department of Corrections Institutional Division to serve the 7-year sentence assessed by the court with credit for time served, with the court making an affirmative finding that the defendant did use or exhibit a deadly weapon, to wit, a machete, as alleged in the indictment. Anything else, Mr. Roberson?
No, Your Honor.
Anything else, Mr. Gilmore?
No, Your Honor.
All right, we're in recess.
Thanks, Jorge.
Thank you, Mr. Trevino.
Receso. Oh, hacen.
All right, we're going on the record in cause number 241-1147-20, State versus Kyriandre Maddox, who is present before the court by Zoom with his attorney, Mr. Clifton Roberson, by Zoom. State's counsel, Mr. Gilmore, is present by Zoom. Mr. Roberson, do you wish to waive the formal reading and presentation of the indictment?
Judge, waive the formal reading of the indictment. His name is correctly set forth in the indictment. Knows the range of punishment, what he's charged with. Gonna change his plea from not guilty to guilty, Your Honor.
Raise your right hand, Mr. Maddox. I have to swear you in. Do you solemnly swear, Mr. Maddox, the testimony you will give in the cause now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, Mr. Maddox, I've got a set of plea documents here to go over. The first one, up there on the screen right now, is the indictment in your case, charging you with unauthorized use of a motor vehicle, a state jail felony, which carries a sentencing range of not less than 6 months nor more than 2 years, 24 months, in a state jail facility, and a fine of up to $10,000. You can see there on your agreed punishment recommendation, it tells the court, apparently you and Mr. Roberson have agreed with the state's attorney that if you plead guilty, the state's attorney will recommend 18 months in a state jail facility, which would be assessed with credit for time served. Is that your plea agreement, Mr. Maddox?
Yes.
Is that it, Mr. Roberson?
That's correct, Your Honor.
Is that it, Mr. Gilmore?
Yes, it is, Your Honor.
Do I need a post-sentence for restitution? It's checked.
I don't think you need a post, Your Honor.
All right.
Yeah.
The next plea document, let me ask you while this one's up there, Mr. Maddox. There's a signature down the right side above the line where it says defendant. Is that your signature?
Yes.
There, it's also signed by Mr. Roberson and by state's attorney, Ms. Anderson. Now, your signature is going to be on all these plea documents, which shows that you signed and swore to the plea documents, the ones that are sworn to. Did you go over each and every one of these plea documents, Mr. Maddox, with your attorney, Mr. Roberson, so he explained each plea document to you so you understood what you were signing and swearing to?
Yes.
Your first one's obviously your plea agreement. You understand unauthorized use of motor vehicles, a state jail felony, carries a sentencing range of not less than 6 months or more than 24 months in a state jail facility, and you have a plea agreement for 18 months in a state jail facility, which would be assessed with credit for time served. That's your plea agreement.
Yes.
The next document's an acknowledgement of admonishments. There is a total of 7 admonishments on the document now. Did you go over that document, the acknowledgement of admonishments, with Mr. Roberson? You signed it right below number 7, as has Mr. Roberson. Do you understand all those admonishments, explanations 1 through 7?
Yes.
The next document is a waiver of trial by jury, where you tell the court you understand you have a right to trial by jury, but then you say you knowingly waive, waiver meaning giving up your right to trial by jury, just ask the court to hear the case without a jury on your plea of guilty. Is that correct?
Yes.
The next documents assigned is sworn to waiver of confrontation. Next documents assigned is sworn to stipulation of evidence. That stipulation of evidence, Mr. Maddox, up on the screen, that is a written judicial confession under oath by you to all the allegations and the charge in the indictment. Do you understand that?
Yes.
Do you just raise your right hand for me? Let me be sure I've got you sworn. Do you solemnly swear that all of the content of the stipulation of evidence signed and sworn to by you is being signed and sworn to freely, intelligently, knowingly, and voluntarily?
Yes.
All right, the court approves states 2, the signed and sworn to stipulation of evidence. We've got an agreement to stipulate testimony on the plea, a form for a waiver of appeal, request for a waiver of the pre-sentence, which is approved, trial court certification of the defendant's rights to appeal, and certification from the defendant back to the court on advice he's received on his rights to appeal. Now, Mr. Maddox, we've already covered the fact that you signed and swore to all of these plea documents. Did you go over each one of these plea documents with Mr. Roberson prior to the time you signed and swore to it, so you understood what you were signing?
Yeah.
Do you still wish to go forward now in this case on your plea of guilty to this indictment with your plea agreement being 18 months in a state jail facility with credit without a jury?
Yes.
All right, do you read, write, and understand English?
Yes.
Have you consumed any alcoholic beverage in the last 24 hours?
No.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No.
Have you ever been under the care of a treatment of a psychiatrist or in a mental institution?
No.
Do you understand everything you're doing in court today?
Yes.
Have you gone over everything about the facts of your case and what you're doing in court today with your attorney, Mr. Roberson?
Yes.
Is he competent, Mr. Roberson?
He is, Your Honor.
Any evidence of incompetence, Mr. Gilmore?
No, Your Honor.
Court notes State's counsel signed his consent and approved the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in the case signed by the defendant, signed by his attorney. All right, now, Mr. Maddox, you do understand all the allegations, the charge and the indictment, the full range of sentencing, and your plea agreement and all these plea papers. Is that correct?
Yes.
Do you have any questions for me about anything?
No.
All right, in cause number 241-1147-20, what is your plea today to the indictment in this cause number charging you with unauthorized use of a motor vehicle, a state jail felony, as alleged in the indictment?
Yes.
Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes.
Anyone threaten you in any way or promise you anything or make you plead guilty?
No.
Are you entering your plea of guilty to the indictment freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in the indictment?
Yes.
Are you entering your plea of guilty to the indictment today because you have any type delusion in your mind or some type unrealistic hope of pardon, parole, or leniency?
No.
The court does receive and accept your plea of guilty to the indictment. What do you have, Mr. Gilmore?
The state will offer States Exhibit 1, the signed plea papers, States 2, the signed stipulation of evidence, and States 3, the signed discovery compliance forms, Your Honor.
No objection, Your Honor.
With no objection, States 1, 2, and 3 are admitted into evidence. The court having admitted into evidence States Exhibits 1, 2, and 3. The court does find the defendant's waiver of his rights, execution of all the other documents were all done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment charging him with unauthorized use of a motor vehicle was entered by the defendant to the indictment freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty. The court does find the defendant guilty of the offense of unauthorized use of a motor vehicle, state jail felony as alleged in the indictment. Moving to sentencing, Mr. Gilmore.
Your Honor, the state will offer States Exhibit 4, a digital copy of the discovery in this case.
No objection, Your Honor.
States 4 is admitted into evidence without objection. The court in this case then, based upon the defendant's plea of guilty, to the offense alleged in the indictment, which the court finds was entered freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty to the indictment, and the court does find the defendant guilty of the offense of unauthorized use of motor vehicle, state jail felony, as alleged in the indictment, and the court does follow the plea agreement and the recommendation of the state. Court assesses the sentence in the case at 18 months in a state jail facility, no fines assessed, court costs are ordered paid. Do we need a restitution on post-sentence?
No, Your Honor, no restitution in this
No
case.
restitutions indicated as due. Credit for time served granted on the sentence. In legal reason to bar formal sentencing, Mr. Roberson.
No legal reason, Your Honor.
Finding none, the court formally pronounces the sentence. The court does find the defendant guilty of the offense charged in the indictment based upon his plea of guilty entered to the indictment and the evidence admitted into the record. And the court finding the defendant guilty of the offense of unauthorized use of a motor vehicle as alleged in the indictment. The court does follow the plea agreement and the recommendation of the state and assess the sentence in the case at 18 months in a state jail facility. No fines assessed, court costs are ordered paid. No restitutions indicated due. Credit for times granted on the sentence. Any legal reason to bar formal sentencing?
No legal reason, Your Honor.
Finding none, the court formally pronounces the sentence. The court does find the defendant guilty of the offense of unauthorized use of a motor vehicle, state jail felony, as alleged in the indictment. Follows the plea agreement recommendation of the state and assesses the sentence at 18 months in a state jail facility. No fines assessed. Court costs are ordered paid. Credit for time served is granted on the 18-month sentence. Sentence is formally pronounced. Mr. Maddox, I have a document from you, signed by you and Mr. Roberson, which gives up your right to appeal. Do you understand that?
Yeah.
Are you waiving giving up your right to appeal in this case freely, intelligently, knowingly, and voluntarily?
Yes.
Court receives and accepts a waiver of appeal. You've been represented in this case by your court-appointed attorney, Mr. Clifton Roberson. Are you satisfied with Mr. Clifton Roberson's legal representation?
Yeah.
All right, you'll be ordered continued in the custody of the sheriff, then Mr. Maddox, until you can be transported to a state jail facility to serve the 18-month sentence assessed by the court for the offense charged in the indictment. The 18-month sentence is assessed with credit for time served. No restitutions indicated as due. Anything else, Mr. Trevino? All right, anything else, Mr. Roberson?
No, Your Honor.
We're in recess. The defendant is continued in the custody of the sheriff until he can be transported to a state jail facility to serve the 18-month sentence assessed by the court with credit for time served. He's continued in the custody of the sheriff until he can be transferred to a state jail facility to serve the sentence with credit. We're in recess.
That was the We're gonna start with Dowdy at low risk.
Okay.
Get you on, bud.
Yes.
All right, we're on the record in calls number 24109-16-19. State of Texas versus Jamal Dowdy, who is present by Zoom. Mr. Roberson, his attorney, is present by Zoom. Mr. Gilmore, State's Counsel, is present by Zoom. Mr. Roberson, do you wish to waive the reading and formal presentation of the indictment charging unauthorized use of a motor vehicle?
Judge, waive the formal reading of the indictment. His name is correctly set forth in the indictment. Knows the range of punishment, what he's charged with. Gonna change the plea from not guilty to guilty, Your Honor.
Mr. Dowdy, just raise your right hand. I have to swear you in. Do you solemnly swear the testimony you'll give before the court today by Zoom will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Dowdy, you can put your hand down, sir. Just look at that screen. The indictment is up there, unauthorized use of a motor vehicle. Have you gone over that indictment with Mr. Roberson, your attorney, so you understand the allegations and the charge in the indictment?
Yes, sir.
You understand that's a state jail felony charge, carries a sentencing range of not less than 180 days nor more than 2 years in a state jail facility. Fine may be assessed of up to $10,000. You have a plea agreement and agreed punishment recommendation between you, Mr. Roberson, and the state's attorney, Mr. Gilmore. But if you do plead guilty to the indictment, Mr. Gilmore, state's attorney, is going to recommend 16 months in a state jail facility. That would be assessed with credit for time served. I'll read that credit for time served into the record after it's fairly lengthy, after we finish the plea. Is this your signature, Mr. Dowdy, down the right side on this first one, the agreed punishment recommendation? It's signed Jamal Dowdy. I can read it, but is that your signature?
Yes, sir.
Did you sign and swear to all these plea documents after you went over each of them with your attorney, Mr. Roberson?
Yes, sir.
All right, I'm going to identify these plea documents for the record. They'll be going up on the screen. Your plea agreement, as I just said, if you plead guilty to unauthorized use of a motor vehicle, a state jail felony, Mr. Gilmore is going to recommend your sentence at 16 months in a state jail facility. That'd be assessed with credit for time served. No restitutions indicated on the plea document. Is that your recommendation, Mr. Gilmore?
That is correct, Judge.
Is that the plea agreement, Mr. Roberson?
That's correct, Your Honor.
Is that your plea agreement, Mr. Dowdy?
Yes, sir.
All right, now I'm going to identify the remaining plea documents I've got. There's an acknowledgement of all these are signed or signed and sworn to by you and your attorney, Mr. Dowdy. There's an acknowledgement of admonishments. The first one's the full range of sentencing. There's a total of 5. You and Mr. Roberson signed below the 5th one. Do you understand all 5 admonishments?
Yes, sir.
Next document signed by you and Mr. Roberson. It's a waiver. Waiver meaning to give up. It gives up your right to a jury trial. You say in the waiver to me, you knowingly and intentionally give up your right to a trial by jury. But just ask the court to hear the case on your plea of guilty without a jury. Is that correct?
Yes, sir.
The next document is a signed, now signed and sworn to waiver of confrontation with witnesses. Do you understand that document?
Yes, sir.
The next document states too is a stipulation of evidence signed and now sworn to by you and signed by your attorney. Do you understand that stipulation of evidence signed and sworn to by you before the court? That's a written judicial confession under oath by you to the allegations and the charge in the indictment. Do you understand that, Mr. Dowdy?
Yes, sir.
Did you sign and swear to this stipulation of evidence of your own free will, sign it voluntarily?
Yes, sir.
All right, the court receives and approves the way stipulation of evidence, states exhibit number 2. Then we've got an agreement to stipulate testimony. We've got a form waiving your right, giving up your right to appeal, waiving a pre-sentence investigation. And we've got another document that waives and gives up your right to appeal. Waives meaning give up. It gives up your right to appeal and gives up your right to file a motion for new trial. Do you understand all these documents, Mr. Dowdy?
Yes, sir.
Do you have any questions for the court about any of these plea documents?
No, sir.
All right. I'm going to go through and ask you a few questions here, then we'll take your plea. Do you read, write, and understand English?
Yes, sir.
Have you consumed any alcoholic beverage in the last 24 hours in the jail?
No, sir.
Are you under the influence today of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir.
Have you ever been in a mental institution or under psychiatric treatment?
No, sir.
Do you understand everything you're doing here in court today by Zoom?
Yes, sir.
Have you been over everything you're doing here in court today with your attorney, Mr. Roberson, including the facts of your case?
Yes, sir.
Is he competent, Mr. Roberson?
He is, Your Honor.
Any evidence of incompetence, Mr. Gilmore?
No, Your Honor.
Court notes State's counsel signed his consent to approve the waiver of trial by jury. Court approves the waiver of trial by jury and all the other waivers in the case signed by the defendant, signed by his attorney. All right, now, Mr. Dowdy, you understand all the allegations, the charge in the indictment, the full range of sentencing, your plea agreement, and all these plea documents you signed, which I've identified for the record. Is that right?
Yes, sir.
Do you have any questions for me about anything?
I was just wondering, is it a possibility that I could finish out the remainder of my time right here in Smith County versus going to state prison?
Well, that's an easy one for me, Mr. Dowdy. I can't answer that question. All I can do is assess the sentence recommended by the state, approved by you and Mr. Roberson, of 16 months in the state jail facility with credit for time served. I will tell you that my opinion will be is that you will have to be transferred to a state jail facility to serve whatever remainder of your sentence there is, because I don't know when you'll be transferred. But the parole process at the state jail or TDC requires you to be there. So you'd have to be transferred from the state jail transferred from the county jail to the state jail to serve whatever time you've got left. And then you would, have completed your sentence or be on parole. You're not going to be able to parole out of the Smith County Jail. You with me?
Yes.
Okay. I believe that's correct, isn't it, Mr. Robertson?
Judge, I was explaining to him, he had a 16-month sentence. He got about 430 days credit. I told him by the time they do the paperwork and everything, it's a good chance that since it's a state jail case, they probably let him go out of Smith County Jail, but that's left up to them, Your Honor.
Right. That's really the bottom line. I'm sure Mr. Robertson is probably right, but I can't tell you that you'll be paroled or have your time done in the Smith County Jail. To quote, to make it sort of legal language, those decisions are left to the Board of Pardons and Paroles and the Texas Department of Corrections, okay?
Yes, sir.
All right, the court then, to be sure I have formally pronounced, I may have lost track of exactly where I was. I believe I was down to pronouncing sentence. Mr. Gilmore, did I come up
Yes.
short?
Yes, Your Honor, that's
Okay.
correct.
All right, the court in this case then, based upon the defendant's plea of guilty to the offense of unauthorized use of motor vehicle, state jail felony as alleged in the indictment, based upon the defendant's plea of guilty, the evidence admitted into the record, the court does find the defendant guilty of the offense of unauthorized use of motor vehicle, state jail felony as alleged in the indictment. The court follows the plea agreement. The recommendation of the state assesses the sentence at 16 months in a state jail facility. No restitution is indicated as due. 16-month sentence is assessed with credit for time served. This isn't official. Those official records are kept by the jail or by TDC or state jail facility. Mr. Roberson has written on here, time credit is 1/15/19 to 1/21/19 in Smith County, 7 days. 6/1/19 to 7/3/19, 33 days. 8/23/19 to 9/24/20. Gosh, it looks like it says Florida.
And he was judge. He was in Florida, and he was incarcerated in Florida. So the state of Texas had a hold on him. When they finished his time in Florida, they brought him back to Smith County, Judge.
All right, and then 9/24/20 to the prison in the Smith County Jail. By Mr. Roberson's calculations, that doesn't mean TDC will reach the same numerical number, but Mr. Roberson indicates 438 days credit. The court's order and judgment will simply assess the sentence at 16 months with credit for time served. It's not the court's job, thankfully, to figure out the time served. You've presented a waiver of appeal to him, Mr. Dowdy, waiving and giving up your right to appeal. Is that correct?
Yes,
Are you giving up, waiving your right to appeal freely, intelligently, knowingly, and voluntarily?
yes,
Mr. Roberson has been your court-appointed attorney. You satisfied with Mr. Clifton Roberson's legal representation?
yes.
Anything else, Mr. Roberson?
No, Your Honor.
Anything else, Mr. Gilmore?
No, Your Honor.
The defendant is continued in the custody of the sheriff until he can be transported to a state jail facility of the Texas Department of Corrections Institutional Division to serve the sentence assessed with credit for time served. We're in recess.
Mr. Maddox. That's not Maddox. Mr. Dowdy.
Yes.
Will you let them know I need Dwayne Sharp next, please?
Okay,
Thanks.
that's it.
Hey, Clifton,
Denise, you have 2 cases on Sharp.
I do, but he wanted to talk to you again before he signed the paperwork, so it'll just be a reset.
Just talk to him. Okay.
Oh, boy.
Do you want just a week or?
You want to see if
yeah,
you can talk to him now or what?
No, I was Zoom with him. On Friday, and we could just do him next week.
He,
Yes.
Denise, he
Wait a minute.
finally decided to sign the paperwork, but I mean, that doesn't help us right now.
Oh, well, if he signed them and you want to email them to me, I can get it done.
Okay, I will do that.
Thank you. Okay, so we'll have to take a little break on him. Do you have Carla Moisash in your office,
He's
Clifton?
in my office, and I can have him come in. We can go ahead and put him on the record.
Yeah, let's do that then.
Okay. Sash.
Mr. Robertson,
Yes, Judge, I'm bringing my client in.
well, look at the screen.
Oh, I know, Judge, I got a blanket until I get around here. That's me with a t-shirt on.
I see it.
I'm just trying to show my muscles.
You almost look like you do when you were in SMU. So, sort of.
All right, can you see us here?
Yeah, we got you, Clifton.
Oh, here we go, Clifton. This is in calls number on the record. Calls number 241-1009-20. State versus Carly Moy, Jermaine Sash, who is present on bond with Mr. Roberson in his office for the offense of sex offenders duty to register with a previous conviction. Apparently, according to the docket sheet, the defendant is on a $100,000 Longino bail bond. Mr. Gilmore is present representing the state. Well, are you ready, Mr. Gilmore?
Your Honor, I just have an announcement on this case. The state was attempting to negotiate with the defendant, Mr. Sash, through Mr. Roberson. The state was going to offer a 10-year TDC offer. However, Mr. Roberson indicated to the state yesterday that Mr. Sash wasn't interested in offer and that he didn't want an offer and that this would be a trial. And so the state will be withdrawing its offer and moving forward on that.
Judge, that is correct. My client is in the office. The court can put it on record that he's refusing or rejecting the plea offer.
All right, Mr. Sash, raise your right hand so I can swear you in. I just have one question for you. Do you solemnly swear the testimony you'll give in the cause now on trial will be the truth, the whole truth, nothing but the truth, so help you God?
Speak up.
Yes.
Got to speak up.
Yes.
All right, of course, the record reflects you were only $100,000 surety bond from Longino bail bonds. Mr. Roberson has conveyed to the court and Mr. Gilmore has conveyed to the court that he has made an offer to Mr. Roberson, which then Mr. Roberson discussed that offer with you. And Mr. Roberson has told the court that you have rejecting and are rejecting, not accepting the state's offer of 10 years. Is that correct?
Yes, sir.
All right, what the court will do now, you're on a Longino bail bond. You'll be continued on your Longino bail bond. Who are you reporting to down at the Smith County Probation Department?
Elijah.
Who's he reporting to, babe?
Is that a lot?
Who's
Is it
his-
Jamaica?
Jamaica Brown.
Jamaica
Oh.
Brown.
Is Jamaica Brown, Mr. Roberson?
Yes, Your Honor.
All right, you're continued on your $100,000 surety bond, Mr. Shash. Continue as reporting to Mr. Brown, as you've been doing apparently. I haven't received any violation reports on you. If I do receive any type of violation report from your supervising bond officer at the probation department, that would trigger a no bond warrant for your arrest. Do you understand that?
Yes, sir.
Well, actually, it wouldn't be a no bond one. The bond would at least triple. So continue to, if you violate any of the conditions, mainly you continue to report, do your drug testing, follow all your conditions of bond. Since you have rejected the plea offer by the state, this case will be tried before a jury. We probably need to go ahead and get a pretrial date on this one, Mr. Roberson, as well as a trial date, so I can explain to the defendant when he has to be back before the court.
Yes, Your Honor.
And I'm getting that from Denise.
Yes, Your Honor.
I mean, I don't know when to tell him.
Well, I mean, I have
Mhm.
All right, Mr. Roberson, since this will be a jury trial, defendant having rejected the state's offer, it'll be set for a jury trial on Monday, January the 20th at 10 o'clock. Correct, Denise?
that's the pretrial. The trial will be January.
It is
25th.
being set for pretrial for the court to hear any pretrial matters on, is that a Monday?
It's a Wednesday.
On Wednesday.
Wait, I don't know what day.
That's okay. All right, Mr. Roberson, be sure you've got this. It's set for pretrial on a Wednesday, on January the 20th. I don't have a 2000.
I got it, Your Honor, on January 20th.
No, that won't work.
Okay, that's Martin Luther King's birthday, I think.
Yeah, pretrial can be on Wednesday, January the 20th at 10 o'clock, and the trial date as of right now is for Monday, January the 25th at 10.
Okay, so what we've got, Mr. Roberson, is pretrial on is that a Monday, January 20th?
It's a Wednesday.
All right. Let me get it right. Pretrial is on Wednesday, January the 20th, 2021. And trial date before a jury is set for a Monday, January the 25th at 10 o'clock. That would be for trial before a jury. Now, Mr. Sash, you need to be sure and understand you're on a $100,000 surety bond. I'm continuing you on that bond under all your conditions of bond. So continue to report as you've apparently been doing to your supervising bond officer. Now, one of the conditions of your $100,000 surety bond is you have to be back in this courtroom on January the 20th at 10 o'clock for pretrial in your case. Do you understand that?
Yes, sir.
And then you are set for trial before a jury on Monday, January the 25th at 10 o'clock. Mr. Robeson will explain that to you. But your next appearance before the court's on Monday, January the it's on Wednesday. I don't have a calendar in front of me for 2021. Your pretrial is set for Wednesday, January the 21st at 10 o'clock. Do you understand that, Mr. Sash?
Yes, sir.
So it's now a condition of your $100,000 surety bond for you to be back before the court on Monday, January the 21st at 10 o'clock. Do you understand that?
Yes, sir.
Continue to follow all your other conditions of bond, which you've apparently been doing, your reporting, drug testing, and all the other conditions. Case is now set for pretrial on the 20th. Did you say 20th, bud? On January the 20th at 10 o'clock for pretrial, trial January the 25th, 10 o'clock. All right, have you got those dates, Mr. Robeson?
I do, Your Honor.
We're in recess until January the 20th, 2021 at 10 o'clock. That's for pretrial.
Thank you, Your Honor. And I'm
Thank
going
you.
to switch back around to my in-jail case, Your Honor.
All right, thank
Hey,
you.
Clifton and
Yeah.
Zach, we're gonna take about a 10-minute recess. Zach, can you run down and sign Mr. Sharp's paperwork, please?
Yep, right down.
Thanks.
All right. Thanks, Denise.
Hear me, sir? Can you hear me?
I can hear you. Everybody else can hear you too. What's up?
I was just wondering, I didn't see on the paperwork where it mentioned anything about what we talked about. the other-
Running CC?
Yes, sir.
Oh, the judge is gonna tell you that. It's gonna be running CC. The judge's gonna tell you that.
Oh, okay.
But your time credit was on there.
And how much was that?
Oh, shoot. What I got written on the paperwork, what I got written on your file.
All right,
Okay. It'll be just a few minutes here.
all right.
All right. Just be patient.
I'm trying to be, and I'm trying not, I don't know much about this law stuff. I hadn't been in a whole lot of trouble.
All right. Just be
Just a little
patient.
nervous, and
Just be patient.
Me-
We
with
get
me
through it,
being
okay?
legally blind and having seizures, I'm kind of worried about going down there to state jail.
Well, just make sure you tell them all your medical conditions, okay?
All right.
All right.
Still waiting.
Hey, just tell them the judge took a 10-minute break. It'll be a few minutes.
She was here whenever he said that.
Oh,
She
okay.
was- She was just checking back in to see if we underway yet.
Oh, okay. I'm waiting. So he'll be here in a few minutes.
Patiently waiting.
All right, we're on the record by Zoom in cause number 241-1348-20 and cause number 241-1564-20. Both State versus Dwayne Sharp, who is present by the court, before the court from jail. And he's present with his attorney from Zoom, by Mr. Clifton Robertson. State's counsel, Mr. Gilmore, is present by Zoom. Two indictments, cause number 241-1348-20, cause number 241-1564-20. Both possession of a controlled substance indictments. You want to waive the reading and presentation of each one of the indictments and all the other formalities, Mr. Robertson?
Judge, in both cases, we waive the formal reading of the indictments in both cases. His name is correctly set forth. He knows the range of punishment, what he's charged with. Going to change his plea from not guilty to guilty, Your Honor.
All right, Mr. Sharp, just raise your right hand. I have to swear you in. You solemnly swear the testimony you'll give and the causes now on trial will be the truth, the whole truth, nothing but the truth. Shall help you God.
Yes, sir.
All right, Mr. Sharp, we'll take them by the numbers. 241-1348-20's indictment charging possession of controlled substance, meth, amount of less than a gram. That's a state jail felony carrying a sentencing range of 180 days up to 2 years in a state jail facility. Fine may be assessed up to $10,000. That's the same over in 241-1564-20. And again, an indictment charging possession of controlled substance, meth, in an amount of less than a gram. That carries the same state jail sentencing range, not less than 180 days to more than 2 years in a state jail facility, fine of up to $10,000. Mr. Sharp, both these pleas are being done at the same time, so the sentence is assessed by the court, but run concurrent at the same time with credit for time served. I want to go through the plea documents with you, though. Each one of the indictments is up on the screen, 1348-20. Have you gone over the allegations and the charge in each one of these indictments with Mr. Robertson, so you understand the allegations and the charge against you in each indictment?
Yes, sir.
All right, going up on the screen now is going to be your agreed punishment recommendation. Is basically the same in each cause number. Down the right side on the, right there, down the right side, you'll see a signature on the line above where it says defended. Is that your signature, Mr. Sharp?
Yes.
All right, it's also signed by Mr. Robertson, by Mr. Gilmore for the state. In each one of these cases, both 1348-20 and 1564-20, you have basically the same plea agreement. If you enter a plea of guilty to the indictment charging the offense of possession of a controlled substance less than a gram in each cause number, State's counsel, Mr. Gilmore, is going to recommend your sentence be assessed at 16 months in a state jail facility. In each case, that would be assessed with credit for time served. And since we're doing the pleas at the same time, the 16-month sentence set by the court under the plea agreement in a state jail facility, they would run concurrent or at the same time with credit for time served. You understand that, Mr. Sharp?
Yes, sir.
I'll go ahead and identify the rest of the plea documents. There is in one of them, 241-1348-20, pursuant to Article 1245, the court will take into consideration, if you do plead guilty pursuant to Penal Code Article 1245, an unadjudicated case under DA number 20-01994, criminal trespass. Are those the plea agreements, Mr. Robertson?
Yes, Your Honor.
Those your recommendations, Mr. Trevino? I'm sorry, Mr. Gilmore.
Yes, Your Honor, that's correct.
Okay. You don't want to interpret on this one, do you?
We wouldn't do a very good job.
All right. We'll move on down through the rest of these plea papers, all signed or signed and sworn to by the defendant. I will issue that oath in a minute. Mr. Sharp, some of these plea documents show they're just been signed by you. Some of them show they are signed and then sworn to by you. So let me get you sworn to each one of these documents. Do you solemnly swear or affirm the testimony you'll give in each one of these cases on trial will be the truth, the whole truth, and nothing but the truth, and that each one of these plea documents which show to be signed and then sworn to by you are being sworn to you by you now freely, intelligently, knowingly, and voluntarily?
Yes, sir.
All right, again, I've covered the plea documents. They're the same in each case. You plead guilty, the state's going to recommend 16 months in the state jail facility. The pleas are being done at the same time, so the 16 months in the state jail facility with credit for time served. Each 16-month sentence assessed by the court, they'll run concurrently at the same time. Each set of plea papers has an acknowledgement of admonishments, gives you the full range of sentencing for this offense, about 7 admonishments. It's up there, and you and Mr. Robeson have signed below the last admonishment. Do you understand all the admonishments in each case?
Yes, sir.
The next document in each case is a waiver of your right to a trial by jury signed by you and Mr. Roberson, approved by the state. Do you understand that waiver? It waives and gives up a right to a jury trial that you have in each one of these cases.
Yes, sir.
Next document, it's another waiver where you give up, like confronting witnesses on the plea, and you agree to stipulate testimony in both these cases, and you've now not only signed, but signed and sworn to this document. Do you understand that document?
Yes, sir.
Next document in each case. Now, the stipulation of evidence states 2 in each one of these cases, signed and now signed and sworn to by you, signed by your attorney. Those stipulations of evidence in each cause number are written judicial confessions and admissions under oath by you to all the allegations and the charge in each indictment and each cause number. Do you understand that, Mr. Sharp?
Yes, sir.
Could you sign and swear to each one of these stipulations of evidence? Just to ask you again, freely, intelligently, knowingly, and voluntarily.
Yes, I did.
All right, then each case has an agreement to stipulate testimony on the plea. Each case has a form for a waiver of appeal. Each case has a request for a waiver of the pre-sentence, which is already approved by the court. And there's a discovery compliance in each one of the cause numbers. Now, understanding the allegations, the charge in each indictment, and your plea agreements and all your plea papers in both cases, do you still wish to go forward on the indictment in each case, charging you with possession of a controlled substance, a state jail felony as alleged, without a jury?
Yes, sir.
All right, court's going to go through and ask you some questions now. Both these pleas are being done at the same time, so both sentences assessed by the court under the plea agreement will run at the same time. These questions apply to the pleas in both cause numbers. Do you read, write, and understand English?
Yes.
Have you consumed any alcoholic beverage in the last 24 hours?
No, sir.
Are you under the influence of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system?
No, sir, I do not.
Have you ever been confined in a mental institution or under psychiatric treatment?
No, I have not.
Do you understand everything you're doing in court today?
Yes, sir.
Have you gone over everything you're doing in court today by Zoom, as well as everything about the facts of each case with your attorney, Mr. Clifton Roberson?
Yes,
Yes.
he filled me in on everything day before yesterday, sir.
Yes, he's very thorough. Is he competent, Mr. Roberson?
He is, Your Honor.
Any evidence of incompetence, Mr. Gilmore?
No, Your Honor.
Court notes State's counsel signed his consent approved of the waiver of trial by jury. Court approves the waiver of trial by jury. All the other waivers in each case signed or sworn to by the defendant, signed by his attorney. All right, now, Mr. Sharp, for purposes of your pleas in each cause number, do you fully understand all the allegations, the charge in the indictment against you, all your plea documents and your plea papers in both cause numbers?
Yes, sir.
And do you still wish to go forward on your pleas of guilty to the indictments in each cause number without a jury?
Yes, sir. I'd like to get this behind me, sir.
We're going to get it behind.
So I could spend the rest of my days with my grandchildren.
Well, once you get it all behind you and you get your time done, whatever it amounts to, that'd be a good plan. Court then in cause number 241, I'm going to ask you just a series of questions here. I don't believe I've gotten to those yet. These questions apply to both cases, just to be sure I've got them. Do you read, write, and understand English?
Yes, sir.
You have not consumed an alcoholic beverage in the last 24 hours in jail.
No, sir.
You are not under the influence of any drug, narcotic, controlled substance, intoxicant, or have any of those substances in your system. Is that correct?
That is correct.
You never have been confined in a mental institution. Is that correct?
That is correct.
And you do understand everything you're doing in court today or by Zoom on both these cases, correct?
Sir.
And you've gone over everything about the facts of each case and what you're doing in court today, your pleas in each case with your attorney, Mr. Roberson. Is that correct?
Yes, sir.
Is he competent, Mr. Roberson?
Yes, Your Honor.
Yes, been competent, Mr. Gilmore.
Oh, Your Honor.
According to those states, counsel signed against consent and waiver. Consent and approval of the waiver of trial by jury. The court approves the waiver of trial by jury in each cause number and all the other waivers. In each case signed by the defendant or sworn to by the defendant, signed by his attorney. All right, in each cause number, you do understand all the allegations, the charge in the indictment, the full range of sentencing, and all your plea papers. Is that correct?
Yes.
Do you have any questions for me about anything?
Well, sir, the only thing I'm worried about is me being legally blind and I do have seizures, and I was worried about my medical status when I get down there. That's the only questions I have for you, sir.
Well, all your medical papers, all your medical health papers that are in the custody of the sheriff's department, they'll be sent down to the state jail facility with you.
And there is no chance of me having a chance to do probation or anything.
Not under the plea documents I have right now. I have to follow the plea documents. Apparently, you've agreed along with Mr. Roberson to accept the 16-month offer in each case by the state, which would be running concurrent or at the same time with credit for time served. So based on the plea papers in front of me, it would not be possible for the court here today to give you probation. I'll be following the plea papers and the plea agreements, which is 16 months in each case, running concurrent or at the same time with credit for time served.
Okay, how many months will I be incarcerated from this time on?
You know, Mr. Sharp, I have no earthly idea. Mr. Roberson's written on here the time credit you will get. That is actually determined by the state jail once you get there. There's no way for me to tell you how much time you would have left. I have no earthly idea, and I don't have anything that tells me.
All right. Thank you, sir.
All right, you're welcome. I believe that I may have gotten off track a little bit, but I don't think I'd gone through these admonishment questions. I may have. Did I? Okay, I've covered the admonishment questions, so we'll just move on to, I believe, if I ask you, Mr. Roberson, if he's competent?
You did, Your Honor, and he is competent, Your Honor.
All right, and you have gone over, Mr. Sharp, all these plea documents with Mr. Roberson, is that correct?
Yes, sir.
And you've gone all the allegations and the charge in each indictment with Mr. Roberson, so you understand it, is that correct?
Yes, sir.
Other than the question that you have already asked me, do you understand everything you're doing in court today on both these cases?
Yes, sir, I do.
All right, in cause number 241-1348-20, what is your plea today to the indictment charging you with possession of a controlled substance, a state jail felony, as alleged in the indictment?
I plead guilty, sir.
In cause number 241-1564-20, what is your plea today to the indictment in that cause number charging you with possession of a controlled substance, a state jail felony?
I plead guilty, sir.
All right. Are you entering your plea of guilty to the indictment in each cause number today because you are guilty and for no other reason?
Yes, sir.
Anyone threaten you in any way or promise you anything or coerce you, make you plead guilty?
No, sir.
Are you entering your plea of guilty to the indictment in each cause number today freely, intelligently, knowingly, and voluntarily because you committed the offense charged against you in each indictment?
Yes, sir. I was under the influence of narcotics and not thinking clearly, and I committed the crime, sir.
Okay, well, you were not under the influence of narcotics and not thinking clear. You're not under the influence of narcotics today, are you?
No, sir. I was at the time of the offense.
Oh, okay. And you're thinking clearly today.
Yes, sir.
All right. Are you entering your plea of guilty to the indictment today because you are guilty and for no other reason?
Yes, sir.
And you are entering your pleas to both these indictments today of guilty freely, intelligently, knowingly, and voluntarily. Is that
Yes,
correct?
sir.
And you are not pleading guilty to either indictment today as a result of any type of delusion you have in your mind or some type unrealistic hope of pardon, parole, or leniency. Is that correct?
Correct.
All right, the court does receive and accept your plea of guilty to the indictment, each cause number. What do you have, Mr. Gilmore?
This time, the state will offer States Exhibit 1, the signed plea paper, States 2, the signed stipulation of evidence, and States 3, the signed discovery compliance form in both cases, Your Honor.
No objections, Your Honor.
With no objection, then court does admit into evidence States Exhibit 1 into each cause number, States 1, States 2, and each cause number, the signed sworn to stipulations of evidence, States 3, discovery compliance and each cause number. Court finding the defendant's waiver of his rights, execution of all the other documents, and each cause number were done by the defendant freely, intelligently, knowingly, and voluntarily. Further, the court does find the defendant's plea of guilty entered to the indictment, and each cause number was entered by the defendant to the indictment, and each cause number freely, intelligently, knowingly, and voluntarily. The court does receive and accept the defendant's plea of guilty to the indictment, and each cause number. Moving to sentencing, Mr. Gilmore.
Your Honor, the state will offer States Exhibit 4, a digital copy of the discovery.
No objections, Your Honor.
All right, States 4, the DPS lab reports and all of the discoveries submitted into evidence in each cause number. Court then in each cause number, based upon the defendant's plea of guilty to the offense alleged in the indictment, in each cause number, the court does find the defendant guilty of the offense alleged against him by the state in its indictment. In each cause number, the court follows the plea agreement, the recommendation of the state. In each cause number, the court assesses the sentence at 16 months in the state jail facility. No fine assessed, court costs are ordered paid, restitution is ordered to DPS in each cause number. For the lab fee analysis in the amount of $180, credit for time served granted. On the sentence assessed by the court in each cause number, the sentences are ordered to run concurrent or at the same time with credit for time served, with the pleas being done in the same hearing. Mr. Robertson has written on the agreed punishment and recommendation, time credit 4/2/20 to 4/3/20, 6/9/20 to 6/10/20, and 7/9/20 to the present. And the defendant gets credit for time served as computed by the jail or the state jail facilities. $180 lab fee restitution ordered in each cause number. Sentence, any legal reason for formal sentencing, Mr. Robertson?
No legal reason, Your Honor.
Finding none, the court does formally pronounce the sentence. In each cause number, the court does find the defendant based upon his plea of guilty and the evidence submitted into the record. The court does find the defendant guilty of the offense alleged in the indictment. In each cause number follows the plea agreements and the recommendations of the state. In each cause number, assesses the sentence in each cause number at 16 months in a state jail facility with credit for time served. Sentences are ordered to run concurrent or at the same time with the pleas done in the same hearing. Pursuant to Penal Code Article 1245, the court will consider under a DA number 20-01994 criminal trespass. Those state will decline that case as part of the two guilty pleas to the offense in the indictments in each one of these two cause numbers. Mr. Sharp, you and Mr. Robertson have signed in each cause number and filed with the court waivers, waiver meaning waiving and giving up your right to file a motion for new trial, and waiving, giving up your right to appeal. Do you understand that?
Yes, sir.
Are you waiving those rights to appeal, waiving those rights to file a motion for new trial freely, intelligently, knowingly, and voluntarily?
Yes, sir. I just want to get this behind me.
Well, we're getting ready to get it behind you as best we can. The court then in each one of these cause numbers formally pronounces sentence. Court does find the defendant guilty of the offense alleged against you by the state. In each indictment follows the plea agreement, the recommendation of state. In each cause number assesses the sentence at 16 months in a state jail facility. In each cause number to be assessed with credit for time served. 16-month sentence in each cause number in a state jail facility are to run concurrent or at the same time with credit for time served. The court has considered the criminal trespass under 1245. Waivers of appeal, giving up right to appeal, waivers of right to file a motion for new trial, both accepted, approved by the court. Be order of the court. The defendant, Mr. Sharp, will be continued in the custody of the sheriff until he can be transported to a state jail facility to serve the 16-month sentence assessed by the court in each cause number with credit for time served, also order to run concurrent or at the same time. Waivers of appeal accepted in both cause numbers. Anything else, Mr. Roberson?
No, Your Honor.
Anything else, Mr. Gilmore?
No, Your Honor.
We're in recess. All right, this is in cause number 241-1182-19, State versus James Tarter. He's present by Zoom. Where is Mr. Tarter present by Zoom? Is he in your office, Mr. Estrada?
No, he's not, Your Honor. I'm standing in for Mr. Platten today. As the court's aware, Mr. Platten has had some health issues the past year, recovering from surgery. He's been in and out. I believe he filed I'm looking at a motion for continuance with a letter from his doctor. And I'm standing in to urge the continuance. I believe Mr. Carter should be appearing via Zoom as well, but I have not spoken with Mr. Tarter.
All right, Mr. Chairman, this is present by Zoom for the state. I've got one motion for continuance in front of me here. I suppose I've got another one in the, do we have just one indictment before the court on this?
Yes, Your Honor.
All right, I've got the motion for continuance. It's signed by Eric Platten. I take judicial notice of it, the allegations in the motion for continuance. There is a letter from a physician attached from UT Health Center, East Texas Physicians. I won't read the letter into the record. There is a verification by Eric Platten, signed and sworn to on October the 20th, 2020 via video conference. So court's gonna, Mr. Chairman, if you have any position on any of this?
Your Honor, I'm not going to oppose the continuance. With that being said, this case is an old case. It's from 2019. None of the facts have changed on this case. Mr. Platten requested the court's permission to do an inspection of the blood vials all the way back in 2019, some 3 months before COVID-19 was ever even an issue in Smith County. At this point in time, I don't have a problem agreeing to pass today, but his letter indicates that he's going to be fatigued until the middle of November. This defendant has had an ample opportunity to know whether or not he's going to accept the state's offer. If Mr. Platten can have another attorney stand in for him for his hearings, he can also have another attorney stand in to do a plea on this case. I simply want to know whether or not the defendant is going to accept the plea offer, and I want to know whether or not this is going to be a trial, because there's obviously work the state needs to do to prepare it for trial. I don't have a problem with the continuance, but I would ask the court to maybe set this in 2 weeks. If the defendant has not made up his mind during that point in time, then we'll just withdraw our offer and it'll either be an open plea or a trial.
That's fine. I know that at this point, what the court can do is, and I would think that you can contact, looking at, again, I'm not going to quote out of the letter, but looking at the letter attached from a physician, I would think, Mr. Chairman, that you could certainly contact Mr. Platten and determine whether or not his client is going to accept or reject the offer.
And I can tell the court, I did have communication with Mr. Platten yesterday. It's my understanding that he had conveyed the bottom line number to the defendant, and that he was considering that, which is why I'm not going to pull the offer today. But I don't want to wait until the middle of November and then come back and still not know whether or not he's going to accept or reject the offer. I mean, that's roughly another month that we're looking at if we go by Mr. Platten's doctor's letter. I think certainly if we give him a week or two to consider what he now knows is the final offer that the state is going to make, he can let Mr. Platten know. And if Mr. Platten can't appear, we can have someone else announce that it's either going to be a plea or it's going to be a trial.
Well, that's certainly that's certainly all correct. My court coordinator Denise has handed me Tuesday, November the 3rd at 1:30. I suppose that's going to be probably a Zoom plea docket. What about that date, Mr. Chairman? It's Tuesday, November the 3rd at 1:30. And I would think that you could contact Mr. Platt, and I'll have Denise contact him. I don't see anything that would, before me right now, that would keep him from being able to appear by Zoom before the court. Or if Mr. Estrada's going to sit in again, where substitute counsel can announce to the court whether or not the offer's has been accepted or rejected, where I know whether or not to put it on trial docket. I can't continue into infinity not knowing whether or not the offer is going to be accepted or rejected. What about that Tuesday, November the 3rd at 1:30? That's what Denise has given me.
That works for the state, Your Honor.
No, Mr. Estrada, would you make a note of that? I'm going to have my court coordinator email Mr. Platten that the deadline for the court to determine from him, which he would be talking to his client to defend it on Zoom. The deadline, if the court does not know whether or not this plea is accepted or rejected on or before Tuesday, November the 3rd at 1:30, this court will not accept any plea agreement. That's the deadline. That's obviously plenty of time for that determination to be made. And Mr. Tarter is here on Zoom with Mr. Well, I'll put it this way, Mr. Platten's not, he's not even on Zoom. So, Mr. Estrada, would you convey this to Mr. Platten? That's a deadline, Tuesday, November the 3rd, 1:30. If I don't have a plea agreement in place by that time, I'm not going to accept one. It'll be a jury trial, whatever we get to it. Defendant's continued on his bond and conditions of bond until Tuesday, November the 3rd at 1:30, when the case is set for recall by the court, either by Zoom if we're still on Zoom or in person. Mr. Estrada, would you convey all of this to Mr. Platten for the court?
Yes, I will, Judge.
All right, you're continued on your bond and all your conditions of bond, Mr. Tarter, until Tuesday, November the 3rd at 1:30, when you have to be back before the court in person or by Zoom, and that's a condition of your bond. Do you understand that, Mr. Tarter?
Yes, sir.
All right, of course, you can pass this on to your lawyer, Mr. Platten. So it will reset until Tuesday, November the 3rd at 1:30. Defendant's continued on his bond and conditions of bond to that date, and that is a deadline as to whether or not this is going to be a plea by a plea agreement or whether or not it's going to be a trial. Anything else, Mr. Chambers?
No, Your Honor.
Anything else, Mr. Trevino? I'm sorry, Mr. Estrada.
No, Your Honor.
All right, do you understand all this that's taken place, Mr. Tarter?
Yes, sir.
All right, we're in recess Tuesday, November the 3rd at 1:30, when the court will recall the case. Defendants continued on bond and conditions to that date.
Thank you, Your Honor.
Thank you, Mr. Estrada.
Hmm.